Right. Our second case is 2019-322 Wooster Floral and Gift LLC versus Green Thumb Floral and Garden Center. For the appellant, Ms. Audie.
Good morning, Your Honors, and may it please the court. Susan Audie for appellant Wooster Floral. I'd wish to reserve 3 minutes for rebuttal. The internet has changed the way we live, the way we work, and the way we buy goods and services. Just 2 weeks ago, this court heard argument about whether buying goods from Amazon.com makes Amazon a supplier under the Ohio Product Liability Act. And just last week, the Supreme Court of the United States heard argument on whether Booking.com was a protected mark under the Lanham Act. Indeed, we are here today under this format, relying on the internet. Given this increasing reliance on the internet in everyday life, both personal and professional, the law finds a way to adapt. It is no different in this trade name as domain name case, although the issue is much simpler, I believe. Wooster Floral is a legally valid trade name. The 9th District said so, and Applee Green Thumb did not challenge that by way of cross appeal, so it is law of the case and not an issue before the court. But it does not follow that Green Thumb can continue to use the Wooster Floral legally valid trade name as a domain name to block customers and divert them to the Green Thumb website.
Counsel, when someone is searching, would they put, do you have any evidence as to what the pattern would be? In other words, if you specifically type woosterfloral.com, that is looking for a particular website. But if you type in Wooster flowers or Wooster and floral, it doesn't necessarily track that Green Thumb pops up. In fact, Wooster Floral pops up.
That's correct, Your Honor. In fact, this is what's the difference, because a search term is very different than a domain name. The domain name here is woosterfloral.com. And in the Sporty's case that we cite in our reply brief at page 1, it says that a customer's most common way of looking for a business is to type in the name of the business and put .com. And that's exactly what happened here. We don't dispute that typing in search terms, where you get a myriad of options and you get different businesses, we don't dispute that that's an okay act. That can be done. But when you use a legally valid trade name like Wooster Floral and add .com, that takes you directly to the Green Thumb website. It is that act that deserves protection, because Wooster Floral is a legally protected trade name.
Counsel, what about the fact that your client let the domain name or the URL lapse in this case? Wouldn't a reversal in this case be a disincentive and for people to protect those names by renewing their claim to that site?
Certainly, it would have been a better practice to go ahead and renew that. But at the time that it was allowed to lapse, the previous owner had believed that she was going to go out of business. Those plans changed, and that's when Ms. Hamburger went ahead and bought the business, continued the business. They sold the trade name along with the business, and it never stopped being used. So that, like I said, that issue about whether it's a legally valid trade name is not an issue before the court. But it doesn't really make a difference that they let it lapse. And to Ms. Grimes' credit, when she first purchased that domain name, certainly she was under the impression that it was not illegally, that it was no longer going to be used. But once she became aware that it was being used and that she continued to use it, knowing that it had value, that's what should be a Deceptive Trade Practice Act. And she knew that it was going to her website. She admitted she buys several of these domain names to divert them to her website.
Counselor, is she I'm sorry, Justice Donnelly, you want to follow up?
Go ahead.
So when Grimes purchased the name first, thinking the business was going out of business, then search situations change. Should she then have to change her course of business because the prior owners decided not to go out of business?
Well, as long as it's I apologize. As long as it's a legally valid trade name and it continued to be used in that way, yes, she once she realized that, then she needed to give up that name, and we were willing to compensate her for whatever cost that she incurred as far as obtaining that name. But once she became aware that the business was still in business and that it was a legally valid trade name that had been used for years and years beforehand as recognized by the Ninth District, then it was her obligation to give that name up and not continue to use it without knowing that it was continuing to be a valid business, that they both sold flowers to the same internet customers, knowing that that's what they did. Of course, a consumer is going to be confused when they land on a Green Thumb website because they both sell flowers on the internet. And they think.
Well, a question with that, Counselor, how then is that confusing? If you put in a domain name and it takes you to a business that's similar or the same, but under a different name.
Because the consumer is looking for Wooster Floral. It's looking for a particular business. And they put in woosterfloral.com because they're looking for Wooster Floral. And instead they get Green Thumb. And that's where the deception is, because they're looking for Wooster Floral. If they were just looking for flowers in Wooster or flowers in Cleveland and a bunch of names came up, that's not going to be an issue. But when you put in the trade name as a domain name and add .com to it, then that makes it a deceptive trade practice because you are confusing. You're going right to that website. You're not making a choice.
Is anyone really confused? I mean, maybe they're a little annoyed that they didn't get where they wanted to go, but they look at the website. It clearly says that it's Green Thumb. I mean, there's no attempt to deceive anyone.
Well, I would beg to differ with you. I believe that it is. They're looking for Wooster Floral, and when this was first being used, you would see Wooster Floral in the web address bar, and then you'd see Green Thumb. But isn't
that a fairly common occurrence? That you're on the internet, you're looking for something, you type something in, you don't end up where you thought you were going to be, so you say, okay, I've got to look some other way. Well, you're not confused about where you are.
When you're putting in woosterfloral.com, you're looking for Wooster Floral and Gifts. That's the trade name that's protected. They're looking for that particular business. If they were just looking for a florist in Wooster and use search terms, those are different than using the trade name as a domain name because it takes you directly to that website. It takes you directly to Green Thumb. If you're using search terms, you're given options of different things. Yeah, then you might not think that, hey, I can pick any one of these. I'm not necessarily looking for Wooster Floral.
Does Wooster Floral and Gifts have a new domain name? Is it Wooster Floral?
They have some other names. They have some Wooster Floral, woosterfloralandgifts.com. They have woosterfloral.net. There are some other ones that they use, but they don't have woosterfloral.com because it's been taken by Green Thumb. So they are not.
If Green Thumb were called Wooster Flowers, change their name to Wooster Flowers, would it still be deceptive to use the domain name?
Either way, it would be deceptive to use the domain name because the protected trade name is Wooster Floral, and that's the name that's being used in the domain name, and that's what makes it deceptive.
Isn't someone that's going to be specifically looking for your client's business more likely to just type in Wooster Floral and Gifts or Wooster Floral, and either way, your client's name is going to come up. Green Thumbs will be on a list with some other florists, down the line, but your client will come up as the primary option in that search. Isn't that correct?
But that's not the point here, though. We're looking for what is the purpose then of having a legally valid trade name of Wooster Floral if you can't use it and you can be the one that uses it exclusively to somebody else's use? Again, I think
So are you saying that one of the things that comes with having a trade name is you just have an automatic right to add .com to your name and you own that?
We're not, that would be a little bit broader, but in a sense, yes, because you're looking at.
Okay, what about .net?
.net, she has Wooster Floral. That's her name.
But your idea seems to be that by having that trade name, that no one else can use woosterfloral.com. Would that also apply to .net? Would that?
Correct. Anytime you're using anytime you're using a legally valid trade name in a domain name, it should be a deceptive trade practice.
Has there been any court that's found something like that?
Well, no, that's why we're here in this court, because it hasn't been addressed by what you're looking at in a lot of federal cases. You're looking under the Lanham Act there, and we cited a lot of cases where you do have where Peterbilt Trucks was used, Peterbilt.com, KenmoreTrucks.com, and
let me ask you about the Lanham Act cases, because it seems they distinguish between different kinds of names that are unique and names that are more generic. And it would seem like Wooster Floral would fall in the more generic category.
But see, then you're getting into whether it's a legally valid trade name. Here, this has been found whether Wooster Floral is legally valid is not an issue here. It has been found to be legally valid. So we're not getting into whether it's generic or not generic. That has nothing to do with this case. And that's why this makes this case so much simpler, because it's already been legally valid.
But if Wooster Floral was not a legally valid trade name, but the exact same scenario happened here, would it be nonetheless, would you still be arguing it's a deceptive practice for Green Thumb to use it this way?
No, we would not be, because there's no protection. Using Wooster Floral has the protection that Ohio law gives it for trade names. And that's what we're saying. That's because it has that protection. It should not be able to be commandeered by Green Thumb to use and divert customers to her website, because it is a legally valid trade name. It has been in use, and it has been found to be that.
Even though Green Thumb legitimately purchased the domain name.
Even though they legitimately purchased it under, I shouldn't say legitimately. I don't believe they were under a false impression. They believed the business was going out of business. But then when it learned it wasn't, and it had continued to be in business, and then that Ms. Heimberger bought the rights as well as the trade name rights, then at that point she should have given up that.
Counsel, who's responsible for that conclusion? I don't think she bought it deceptively. She, on good authority, that the business was going to fold.
No, we're not faulting her for that. She did think it was going under, so there is no issue there. But once it was brought to her attention, that evidence was brought out during the trial, that yes, she knew that, she was contacted. There was a cease and desist letter sent. She said, no, this name has value. I'll sell it to you for $10,000 if you want $10,000. And that's the whole point of having trade name protection, is that someone else can't commandeer it for their own use and benefit from that. She is benefiting from this by getting customers to go to her website, thinking they're going to Wooster Floral's website.
But then when they get to the Green Thumb website, obviously these people can read, or they wouldn't be searching this way. They get to Green Thumb Floral and Garden Center, and they say, wait a second, I didn't want that. Just like if I type in sometimes the name of my bank, it brings up a host of other banks on the internet. I know that's not what I want, so I keep searching, much to Justice DeWine's point. So your premise that people get to a website searching for one and land on another, and then they're confused and they don't know how to then get to where they want to go. I don't see that as being a valid premise.
But it is, because the deceptive act is once they've registered that name, once they've taken control of that name, and the person has used it and is using, even if they, to the point that they've commandeered it and used it for that purpose, that is the act. It's not once they get to the Green Thumb site, because what they've done is they have the intent to block Wooster Floral customers from going to Wooster Floral and going to Green Thumb. It doesn't have anything to do. Once they get to the Green Thumb website, they may think, well, maybe the two of them are connected. Maybe one bought out the other. There's all this likelihood. It doesn't have to be actual confusion. It just has to be a likelihood that there's some confusion. And there is a likelihood here.
So exactly. Let's talk about likelihood of confusion. At the trial court found not enough clear and convincing evidence, as did the appellate court. Isn't that what we're looking at?
Well, that precise issue as to whether clear and convincing evidence is required has never been addressed by this court. In fact, we would say that clear and convincing evidence is the wrong standard. When you're looking at the likelihood of confusion, commentators in the trademark area saying it's even a less than a preponderance, although we're not going to argue with that, because you're looking at the possibility, a likelihood of confusion, not an actual confusion. So you're not looking at clear and convincing evidence. You're going to look at any type of, as you would in any civil case, a preponderance of the evidence. Neither the deceptive trade practice statute or anything with injunctive relief requires a clear and convincing standard, and that's what the courts imposed. That started actually in the first district. There started some.
Ms. Hardy, I'm sorry, and I see you're running out of time. Just quickly want to ask a question. If the appellees were Joe and Mike's Tires, but used the Wooster Floral name, would your argument be the same?
To direct them to Joe's Tires?
Yes.
No, the argument would be because they're two different businesses, they're not selling to the same internet customer. So there would be no misuse there or misappropriation. And I see I'm out of time. I will reserve the rest of my time for rebuttal.
Thank you. Mr. Reynolds?
Thank you, Your Honors. My name is Craig Reynolds. I'm here on behalf of the appellee Green Thumb Floral and Garden Center. And I do think that the standard of proof that the court is going to use is important here. The trial court just found that the plaintiffs did not prove that there was a likelihood of confusion. The trial court didn't even state what standard of proof it was using.
Counsel, isn't that a problem then? Isn't it a problem that the trial court did not state what standard of review it was using? Maybe it was using clear and convincing. How do we know that?
We don't know. We know that the appellate court used clear and convincing because they stated in page 3 of their decision that they were using clear and convincing evidence of a likelihood of confusion as their standard of proof. And they cited the numerous appellate cases from around Ohio in support of that. And the brief in this case filed by the appellant indicated that the appellate court used the wrong point in time. They didn't argue about—
Before we get off get away from the standard of review, what's your argument about the standard of review? You've said the trial court didn't tell us what standard it was using and that the Court of Appeals used a clear and convincing. What's your basis for saying that was correct?
Well, that is what the Ninth District used previously in other cases, particularly the Cesare versus Work case. And that was based on the Frisch's Restaurant and Elby's case out of the federal court. And the appellant didn't argue that was the wrong standard of proof. Their brief said the appellate court looked at the wrong period of time, not used the wrong standard of proof. I would submit that the standard of proof was not challenged here, and it is, in fact, the clear and convincing that was used by the Ninth District Court of Appeals. I would also say that regardless of what standard of proof is used, there was no proof at the trial level of any likelihood of confusion. The phrase Wooster Floral, Ms. Heimberger of Wooster Floral testified anybody looking for flowers in the Worcester area would type the term Wooster Floral, her protected trade name, into the toolbar to conduct a search. And they would come up with pretty much all the florists in the Worcester area that sell flowers.
Not if you type WoosterFloral.com.
Actually, if you type WorcesterSpaceFloral.com, their protected trade name, you do still come up with a list of names. If you type Wooster Floral with no spaces.com, you do go to the Green Thumb website. And the Green Thumb website, everybody has noted. Ms. Heimberger on the witness stand, Judge Wiest at the trial level, and the Ninth District Court of Appeals have all noted that the Green Thumb website is clearly marked Green Thumb.
Well,
But they're
but, and that's obvious, but why wouldn't there be confusion? If I'm looking for Wooster Floral to order something online from there and I get the Green Thumb website, and you're right, it clearly says Green Thumb, why wouldn't I believe that maybe the two companies had combined, the two companies are one and the same, it's under same ownership, that Wooster Floral derives some profit from Green Thumb's sale? Why wouldn't I connect the two and be confused about being taken to another floral website?
Well, because if you are looking for Wooster Floral, you know that they're not located in the Green Thumb building.
How do I know that? How do I know that?
Well, I assume if you're looking for Wooster Floral, it's because you like their business.
And I want to order flowers from them online.
Okay. And Green Thumb has been in its location for 50 some years. It's in a town of 20,000 people. It's clearly stated where it is and where it's.
But I guess what you're arguing is the locals will know without question. But
Right.
if I want to order flowers for some event in Worcester and I want to go to a Worcester floral shop, and I type in Wooster Floral and I get Green Thumb, why? And I don't know the locale. I'm not, I don't know of the institutions themselves. Why wouldn't I just think the two were the same?
Well, there wasn't any evidence at trial presented as to what people type in. What you just described, looking for flowers in Worcester and typing in Wooster Floral, would not lead you to the Green Thumb website. It would lead you to a directory of florists that sell flowers in Worcester. And in that list would be a number of Worcester businesses, actually some out-of-town businesses as well. And Wooster Floral would be in that list, Green Thumb would be in that list, and so would about 15 other businesses.
Counsel, are you saying that no matter what the standard is, there was no evidence of confusion presented at the trial court?
There was none.
Okay, and that's what the Court of Appeals also recognized, even using maybe the erroneous, clear, and convincing.
Correct.
So even under a preponderance, if there was no evidence, there was no evidence.
That's right.
But counsel, but when you're talking in that response to Chief Justice O'Connor, what you seem to be focusing in, though, is once somebody gets to that website, once they get to the Green Thumb website, they can't be confused because they can see that it's Green Thumb and it's not Wooster Floral. But doesn't that just beg the question of when the confusion occurs? And if, as Justice Stewart said, I'm looking specifically for WoosterFloral.com and I plug that in, isn't there confusion at that moment? Isn't that when the deception actually occurs? That's how I understand the appellant's argument, not that there's confusion after you get to Green Thumb. It's about the starting point of the deception.
I think that accurately describes the appellant's argument. That there's confusion when you type WoosterFloral.com, but there's no evidence at the trial level. There's no authority that indicates that customers looking for Wooster Floral will type WoosterFloral.com into their browser. The evidence is that people and there's no evidence of what people do. It's just our own experience. And our own personal experience is we type in the name of the business without modifiers, without .com, .net, .gov, and we see what we get. As an example, when I was looking for the Ohio Supreme Court, I typed Ohio Supreme Court in, and I don't get your website. I get a different website selling me forms.
But that's not the question. The question is, if somebody else were to purchase the domain name OhioSupremeCourt.com, and that's our domain name, that's where the deception lies. So what I'm not hearing you respond to is about that deception. And if we look at the federal cases that the appellant has cited, that's what they lead us to, is that if you take a domain name knowing that you're going to deceive customers by directing them to your website. That's where the confusion is. That's where the deception is. So do we have a test in Ohio that tells us what factors we ought to be looking at? Do we need a test? I don't hear a response to those issues in appellant's argument.
We clearly don't have a test in Ohio. There's nothing other than the statute that says creates a likelihood of confusion. There's no Supreme Court decision interpreting that. And so we still have to look at the likelihood of confusion. And there wasn't evidence at trial presented about likelihood of confusion. There was evidence presented. You've taken our protected name and added .com to it, and we should win. But there wasn't evidence of likelihood of confusion. And I still think there has to be evidence if you're trying to get injunctive relief and attorney fees and damages. You have to produce evidence to establish a likelihood of confusion. We can't.
Doesn't the statute tell us what the likelihood of confusion has to be about? It says confusion about the party's goods or services. I mean, doesn't that answer the question about whether or not initial confusion about or initial misdirection is the issue? Isn't the issue whether you're confused about the goods or services?
Correct. It does say those terms, Your Honor, and these terms are so generic. Wooster and Floral, they can be found in pretty much every florist in Wayne County's advertising uses those terms. And so we have to assume people using the internet are smart enough to read what they're seeing and look at that to see, who am I shopping from? Am I shopping from Bueller's or C.R. Bloom's or Compatibles or Wooster Floral or Green Thumb or any number of other florists? Before we come to the conclusion that people are confused. I don't think that any evidence was presented. I know that the judges that reviewed this at the trial level and the Court of Appeals did not find any evidence of confusion. And I believe that this court could indicate that in order to prevail on this theory, the person seeking injunctive relief must show by clear and convincing evidence the likelihood of confusion.
Counsel, my confusion here is whether it's confusion or is it deception? Likelihood of confusion, is that, because there's a lot of confusion when you do searches on the internet, even if you think you're typing in a domain name that makes sense for the business you're trying to reach, but that doesn't necessarily mean it's the foundation is deception.
Well, I mean, the statute indicates, with the purpose of deception. So I think they also need to show that.
Okay, and is the fact that they're using a legally protected trade name, is that sufficient to establish deception?
I don't think so. If that were the rule of law, then every florist in Worcester would go out of business because they use those legally protected terms, Wooster and Floral, in their advertising.
Right. But the using together Wooster Floral, they don't use the Wooster Floral business name.
They don't. But what if they use the phrase Worcester's best florist, Worcester's oldest floral shop? How would that, if using the term Wooster and Floral is deceptive, then all of those things would lead to causes of action and demands for money and damages and injunctive relief.
But Mr. Reynolds, so are you saying because the terms are so generic, so if it if the name purchase was Becky's Floral and it took you to the Green Thumb website and Becky's Floral was a protected name, would that then be deceptive?
Would certainly be more deceptive than this current scenario. I don't know if it would rise to deception or not, but if Becky's Florist is more specific than Wooster Floral.
But nonetheless, Wooster Floral got that name protected, got it trademarked, correct?
They do have the trade. They don't have a trademark. They have a trade name.
A trade name, I'm sorry, yes.
Um,
They grabbed it first, even as generic as it might be. So
Right.
that you admit that there is legal protection there.
There is legal protection there. That protection doesn't mean no one else can use the phrases Wooster and Floral in their advertising. They're prohibited from doing it in a way that creates a likelihood of confusion or misunderstanding and is deceptive.
And so if you use that name to direct business directly to your website, how is that not deceptive or confusing or both?
Both parties have purchased multiple domain names and have multiple domain names. And I'm not probably smart enough to understand how search engines work, but those domain names are sold by GoDaddy with the promise that using these phrases in your domain names is going to draw other people to your website. And so, many businesses have many domain names, but all centering on their homepage, which customers have to look at to see what homepage am I on. And Green Thumb's homepage clearly identifies by name, address, and all examples that this is Green Thumb.
Well, at least if I put in WoosterFloral.com and got to Green Thumb's website, would I at least scratch my head and go, how did I get here?
I don't know. You might scratch it. You might do that. Again, I think that assumes that people are typing in WoosterFloral.com when they're looking for the Wooster Floral business. And I believe, in my experience, people type in Wooster Floral when they're looking for Wooster Floral business. There's really no evidence at trial to tell one person they're right and another person's wrong.
Thank you.
Thank you, Counsel. You've used your time.
Thank you very much.
Mr. Audie, or Miss Audie, I believe that you've used your time. You may take a minute.
For one of the first points is there is a test for likelihood of confusion. It is the Frisch Sixth Circuit's decision in Frisch. It was cited by the Bedford Auto Dealers versus Mercedes-Benz and Leventhal on page 15 of our brief. It is an 8-factor test. You're looking at the strength of the plaintiff's mark, the relatedness of goods, similarity of the marks, evidence of actual confusion, marketing channels, likely degree of purchaser care, defendant's intent, likelihood of expansion of product lines. Not all factors need to apply. They may not apply in a given case. Here, you're looking at the strength of the plaintiff's mark has been diluted because Green Thumb has commandeered it and has taken control of it, recognizing that it has value and that she used the exact name of a trade name in her domain name, strengthens that. All the other factors weigh in favor of Wooster Floral because they both sell flowers to the same internet customers. Counsel, again, is confusing search terms with a domain name. And
so, Counsel, are you advocating then that we do adopt the 8-factor test?
Yes, that is. The courts in Ohio have done it. They've been intermediate appellate courts. The Sixth Circuit has done that. This court has looked to the Sixth Circuit.
When I asked you earlier about the strength of the mark, you said that didn't matter because it's already been found to be a trade name. But if the 8-factor test, it clearly does matter that it's Wooster Floral and it's not Peterbilt or something stronger than that.
Well, I apologize then if I said that to you. I didn't mean to say that. No, there is this 8-factor test. Strength of the mark is one of the factors.
And isn't that because it's a generic name very low here?
We would say yes, it probably is a weak name because it does have a geographical, but it's been made stronger by Green Thumb's commandeering of it and using the exact same name and recognizing that it has value. So yes, they've looked at that and all the other factors in addition to the strength of the mark and looking at that this was a legally valid trade name. It's still looked at by courts as saying, yes, this has value. That mark is stronger than when it was just alone, just by Green Thumb's actions. And you look at it from the time that she registered that, because that's the deceptive act at the time that she registered to block other people from going to Wooster Floral.
Was there evidence presented below about confusion?
Yes, yes, there was evidence presented. Again, you don't need actual confusion, you need likelihood of confusion. There was evidence presented. Ms. Heimberger was one of the witnesses. Her husband was one of the witnesses. There was the former owner was a witness. There was cross-examination, certainly, of Ms. Grimes. So there was evidence. And when you're looking just at Wooster Floral, you're looking at it there. That is the evidence right there, because you put woosterfloral.com as a domain name and it takes you directly to Green Thumb. That's the evidence that you need. The evidence that she registered it.
Counsel, how is that evidence? The owner speculating that they believe. Did you bring in any witnesses that said that they experienced what you're alleging and were confused at all?
But then you're looking at actual confusion. I think the confusion here is trying to look for evidence of actual confusion. It's only a likelihood of confusion. And by having the testimony of the people who have purchased, who own the trade name and showing that it goes to Green Thumb is really all the evidence that you need at this point to show that there is likelihood of confusion. And to the extent that there's other witnesses, they had the husband testify, they had the current owner testify, they had the former owner testify. Yes, then there was actually some testimony that there was a former client or a customer who had looked for Wooster Floral, landed on Green Thumb, didn't like the flowers that she got, and it was
Counsel, was that customer at trial? Did that customer testify?
That testimony came through the former owner of Wooster Floral, saying that they got a complaint from a customer who got flowers from Green Thumb, and she complained on Wooster Floral's website saying, I didn't like the flowers you sent me. It's like, we didn't send those flowers. Green Thumb sent those flowers. But again, that's evidence of actual confusion, not likelihood. You're looking for the possibility that someone looking for Wooster Floral is going to be directed to Green Thumb, and there's a possibility of confusion.
Thank you.
Thank you.
Thank you. We will take the matter under advisement. Thank you.
Thank you.